Today we have leading experts to discuss the IPR process and its benefits to the patent system. Before we begin, here are a few housekeeping notes. This panel is being recorded and will be available later. Also, we encourage attendees to use the chat function to ask questions of the panel. And now I'm honored to introduce our guests. Melissa Wasserman joined the University of Texas Law faculty in 2016. Her research focuses on the institutional design of innovation policy, with a particular emphasis on patent law and administrative law. Her articles have been published or are forthcoming in journals including Stanford Law Review, California Law Review, Northwestern University Law Review, Vanderbilt Law Review, Texas Law Review, Duke Law Journal, Review of Economics and Statistics, Journal of Public Economics, and Journal of Empirical Legal Studies. Prior to joining the Texas faculty, she served as professor at the University of Illinois College of Law. Her work has been selected for presentation in the 2015 Yale, Stanford, Harvard Junior Faculty Forum, and in 2012, she was awarded the University of Illinois College of Law's Carol P. Hurd Award for Excellence in Faculty Scholarship, which is given to the most outstanding piece of faculty scholarship published in the previous year. Artie Rai is the Elvin R. Latty Professor of Law and Faculty Director at the Center of Innovation Policy at Duke Law. She's an internationally recognized expert in patent law, innovation policy, administrative law, and health law. Professor Rai's extensive research on these subjects has been funded by NIH, NSF, Arnold Ventures, the Kaufman Foundation, the Greenwell Foundation, and the Woodrow Wilson Center. Professor Rai regularly testifies before Congress and relevant administrative bodies on innovation-related law and policy issues, and regularly consults with federal and state agencies on these issues. From 2009 to 2010, Professor Rai served as the administrator of the Office of External Affairs at the U.S. Patent and Trademark Office. In that capacity, she led policy analysis of the patent reform legislation that ultimately became the American Invents Act, and worked to establish the USPTO's Office of Chief Economist. Prior to that time, she had served on the President-elect Obama transitions team, reviewing the USPTO, and prior to entering academia, Rai clerked in North District of California and was a litigator at Jenner and Block and the Department of Justice. Rai graduated from Harvard College, magna cum laude, with a degree in biochemistry and history, and attended Harvard Medical School for the 1987-88 academic year, received her JD cum laude from Harvard Law School in 1991. Professor Keith Robinson is an Altshuler Distinguished Teaching Professor, co-director of the Sy Center for Law, Science, and Innovation, and Associate Professor of Law at the SMU Dedman School of Law. He has commented on issues of intellectual property law and media outlets and given more than 70 presentations around the world on patent law. Thomson Reuters has twice recognized Professor Robinson's articles as the best that year in intellectual property law. His recent work has explored the impact of emerging technology such as the Internet of Things on patent law. Robinson's work has been cited in briefs before the U.S. Court of Appeals for the Federal Circuit. The Federal Circuit has also cited his work favorably. Professor Robinson graduated from Duke University, earning a BS in electrical engineering. He received his JD cum laude from Duke University. After law school, he worked for the Washington, D.C. law firm of Foley and Lardner, where his practice focused on patent law. Before joining the SMU faculty, Robinson was an adjunct professor at the George Washington University School of Law. All right, Professor Wasserman, I'd like to start with you. You've done a lot of research on the Patent Office, error rates, and how to improve them. Can you start us off by explaining how these mistakes get made and why we need to build ways to correct these mistakes into our patent system?
Yes. That worked. There we go. So thank you. So the Patent Office, as everyone knows, the primary mission, right, is to provide high quality and timely review of patent applications. But this actually is a relatively difficult task. The agency makes over about 500 patentability decisions a year, often faced in budgetary shortfalls, high examiner turnover, and a backlog. So it's not too surprising, I think, that the agency may at times make mistakes and allow invalid patents. Now, the literature has chronicled a series of harms that are associated with these invalid patents. They include super competitive pricing and less access without any innovative benefit. Invalid patents can impede follow-on innovation to the extent they build on previous innovation. They may also impede competitors from entering the market. And there's been a concern recently that non-practicing entities, or who are more derogatorily referred to as patent trolls, are using these invalid patents or low quality patents to extract rent from innovators. So what I want to do is spend a little time just briefly presenting some empirical evidence that suggests there's certain features of the agency that may be contributing to them issuing invalid patents. And then I want to conclude by arguing that sort of litigation alone is probably insufficient to weed out these invalid patents. So each year, the Patent Office gets about 500,000 patent applications filed. They come in and they're routed to an art unit that comprises of approximately 20 examiners who review applications in the same technological field. The supervisor of that art unit then generally randomly assigns that application to an examiner. When it comes up on her queue, she's going to do a prior art search and determine whether the claims meet the patentability standard. But on average, examiners are only spending 19 hours reviewing a patent application. And this includes reading it, searching the prior art, writing up an office action, etc. And because patents are presumed valid, if an examiner does not have enough time to conduct a sufficient prior art search, she may grant a patent that otherwise she would have rejected. And there's lots of anecdotal evidence, right, quotes from examiners themselves that suggest they're not given sufficient time. So our prior work empirically tested whether time allocations of patent examiners were actually inducing them to allow patents of dubious quality. And we went about doing this by exploiting the fact that when examiners get promoted up the GS scale, each promotion is associated with about a 10 to 15% reduction in the time they're given to review a patent application. So by the time you're a GS 14, you have about half the time to review an application as when you were a GS 7. And what we did was just track individual examiners' granting behavior as it varies over the course of their career, and include when they experience these examination time decreasing promotions. So I just want to show you one quick result from this, just to highlight some of the findings that we had. And right here, what I'm showing you is a relationship between the GS level and the grant rate of an examiner. And you can think of this as following an individual examiner as she gets promoted up the GS scale. So remember, each promotion is associated with a reduction in time about 10 to 15%. And what we see is the examiner's grant rate goes up and up and up with each promotion. So by the time you're a GS 14, your grant rate is about 18 percentage points or 26% higher than you were a GS 7. Now, in our prior work, we also found markers to suggest these additional patents you're allowing because you're time constrained are of dubious quality or likely invalid. So the implication would be is if we gave examiners more time, they may allow fewer invalid patents. And we actually simulated if we doubled examiner time allocations, we thought the Patent Office's grant rate could drop by as much as 27%. Now, I want to point out there's been a lot of other research, right, that's pointed out potential causes of why the agency may at times allow invalid patents. So we've done some work, Michael Frakes and I, about the fee structure of the agency, as well as its inability to reject a patent finally, may also create incentives in certain circumstances for them to allow patents of dubious quality. Others have argued it's the count system of the examiners or how examiners get their productivity or their reviews. May also induce patent examiners to allow patents of questionable quality. Others have argued that there's a lack of non-patent prior art, right? So examiners don't have the right prior art in front of them, so they can't make the proper rejections. And some have said, right, maybe it's just the ex parte process, the fact that it's an examiner associated with an attorney who may have many more resources, right, that have some sort of ability to wear down the examiner. And so eventually they may allow a patent that's more questionable. So the question then is, if we establish this idea that it's almost impossible, I think, for the PTO to get it right 100%, there's certainly going to be reasons why invalid patents are allowed. What do we do with them? And why isn't it sufficient just to rely upon litigation to weed out invalid patents? Well, I think it's important to keep in mind that litigation is really expensive, right? There's averages of $1 to $10 million for lawsuits. And this really can limit the access of small companies or small inventors to access a legal system, right, to take on these invalid patents. And then there's also concerns about these non-practicing entities that have adopted a legal strategy, right, that some people argue of using low quality patents and suing a bunch of individuals, right, so that they can extract licensing fees, knowing these individuals or these small companies really can't afford to litigate their patents to finality. It's also important, I think, to keep in mind that there's a delay, even if we rely on the litigation system, between when the patent's issued and when it's actually going to be invalidated in litigation. So litigation on average is filed 7 to 10 years after the patent's issued, and it may last 2 to 3 years before it's resolved. During that whole time period, right, the harms that are associated with invalid patents could be being put on society while we're waiting for the courts to work through. So I think, it's really what we want is some sort of optimal mix. So I think personally the Patent Office should spend more resources on examining patent applications. And Michael and I have some work where we've argued the costs associated with increasing the resources to the PTO so they allow fewer invalid patents really outweigh the costs in doing so. But I also think, as what is highlighted in this webinar, that the post-grant opposition system, right, IPR and PGR is an important part of that. This provides a cheap and faster way to take out invalid patents as opposed to just litigation. So that's what I have. Let me stop sharing.
Thanks a lot, Professor Wasserman. I want to turn now to Professor Rye. So you were involved in the creation of IPR in the what became the American Events Act. Can you walk us through that process and what the goals of the program were when it was being formulated?
Sure. First of all, thank you for the invitation to do this. It's one of my passions, inter partes review, and as you know, I devoted time to it when I was in the Obama administration. So Melissa's excellent work with my colleague at Duke, Michael Frakes, has shown that errors in the Patent Office are fairly pervasive. And her work, together with Michael, has shown really important patterns in these errors. But even prior to her work, for all of the systemic reasons that Melissa has already articulated, in particular the ex parte nature of the process, there was a recognition that the Patent Office would be likely to make errors in grants. And that happened as early as 1980, when the first re-examination system was set up. And just to walk us through a little bit about why an ex parte system where there's a strong financial incentive only on one side is likely to result in errors, let me go through the institutional structure of how a denial versus a grant resolves itself. So if a patent is denied, the patent applicant, of course, has a strong financial incentive to challenge the patent denial. And it will do so, and including all the way to an appeal to the Federal Circuit. But if a patent is granted, there's no robust mechanism prior to the patent grant for a financially interested entity to challenge that before the grant occurs. We don't have any sort of robust pre-grant process for a financially interested entity to go in and challenge what's going on. And patent examiners are, as Melissa and Michael have pointed out, under extreme time constraints. In addition, they may not have access to all of the relevant prior art simply because, again, the prior art is going to come primarily from the applicant itself and any searching that the examiner can do, which is very time constrained. So there's a real asymmetry in the system, and that's something that's been recognized for a very long time. But nothing was really done about it in any robust way, even though as early as 1980, the asymmetry was recognized. And it was also recognized, I think, as early as 1980, hence the implementation of an early re-examination system, that Article 3 litigation was not the best way to correct the errors in grants that were likely systematically to occur. Melissa has already alluded to the cost problem. There's also the problem related to cost of what economists would call collective action. There's Supreme Court case law on non-mutual defensive collateral estoppel that says that if you invalidate a patent, if you spend the millions of dollars necessary to invalidate a patent, you invalidate it for the world, which means all your competitors can free ride off the money that you spent. And that is a real disincentive to use litigation. There's also a real lack of expertise in the district court, and to some extent, I would say even the federal circuit, with respect to the complex science that can be involved. And I think it's even worse at the district court, and there's been a lot of writing, including my own, on this, regarding the role of juries, which have become, by the way, increasingly pervasive in the system. And then finally, less remarked upon, but related to the expertise point, is there's a traditional administrative law of the administrative agency being the first place one should go for correction of an administrative agency's errors. This is a doctrine known as primary jurisdiction. And for that reason, as we'll see, all of the reexamination systems that have been set up over the years have involved a situation where one didn't have to have the significant hurdle of standing to ask for re-exam. So re-exam was set up, as I said, as early as 1980, but the problem was that the systems that were set up as an institutional matter weren't particularly robust, and therefore they failed in their job of efficient, accurate, expert error correction. The basically institutional setup, we can go into it in the Q&A, was quite underfunded, and initially actually the same examiner who granted the patent was supposed to re-examining it, which has obvious limitations. So in the 1990s and the early aughts, there was a flood of obvious software patents, particularly in the business methods area, and that created a flood of attention, including in the popular media. So the Amazon one-click patent and all the rest of it. And later on, some of these poor quality patents that were granted during the dot-com era became the source, I think, of the patent assertion entity phenomenon that happened subsequently, because when we got the bust, these patents were sold at auction and bankruptcy proceedings. So this was a very sort of hot issue in the aughts, and the idea of a more institutionally robust post-grant opposition really began to gel then. There was some inspiration, I think, that was drawn by some economists from Europe's system of post-grant opposition. And in addition, there were very influential reports starting in 2003 from the Federal Trade Commission and the National Academies of Science. The Federal Trade Commission was very interested in this issue because it saw this flood of patents as rightly anti-competitive set of practices. So it perhaps overstepped its jurisdiction according to some, but went ahead and published a really prominent report that was excellent back in 2003. So there was a lot of agreement that something needed to be done, but a huge division over details. So should the post-grant opposition window be open only for a short period of time after the patent was granted, or for a longer period of time? Should there be one opposition window for a short period of time that was more robust, and then a later opposition window that opened up if the patent was asserted in litigation that was perhaps less robust or equally robust? Relatedly to the robustness, should all grounds be available, or what grounds should be available at what times? Was there a particular reason to single out, for example, computer implemented business method patents? Should the preponderance of the evidence standard be the standard that's used for post-grant opposition, as opposed to the clear and convincing evidence standard in district courts and the federal circuit, because this is an administrative procedure, not just a substitute for district courts? And so what we got was a grand compromise, which, you know, as with all grand compromises, has pluses and minuses. So it's not quite, the AI, I don't think, is a super statute in the way of the Affordable Care Act, which was, by the way, passed the year prior to the AIA. But I think some of the same principles of compromise, which create some, you know, some legislative sausage, are evident. And so the IPR is only available, this PGR is only available for 9 months. The IPR is available throughout the life. I don't think all of that is necessarily fully justified in some grand theoretical framework, but that's what we have. And as we know, the IPR has been the most popular, although I should note that at the time of the creation of these various different systems, it wasn't necessarily thought IPR would be the most popular. PGR, which allows challenge on any grounds, was thought to be more comparable to the European system, and perhaps as a consequence might be less more popular. As it turns out, of course, IPR has been the dominant mode of post-grant opposition. So thank you.
Thanks. And Attorney Professor Robinson, you have an interesting perspective because you've been on both the plaintiff and defendant side as a practitioner, and now you study the impact of administrative patent policy on emerging technology. Can you explain how IPR works from a practical point of view?
Yeah, so I'd like to talk about sort of IPRs and access to the patent system. When I talk about access, I mean the ability to make use of the system by stakeholders. And stakeholders include, of course, inventors, but they also include others such as the public or the competitors of patent owners. And one of the unique features about the patent system is that in general, it's relatively transparent. Generally 18 months after an applicant files an application, that application becomes public and that information is accessible to the public. And because the average time it takes to obtain a patent is generally hovers around 3 years, that means that this information is made public very early on in the acquisition process. And so before IPRs, a frequent question a patent attorney like myself might receive from their clients in a competitive field is, how could I prevent my competitor from obtaining this patent that they just applied for? What can we do about this? And generally speaking, there weren't a lot of options available to a client in this situation. One thing that the client could do is, during a narrow window of time set forth in the regulations, they could submit printed publications to the patent examiner with the hopes that that examiner would use that information to do a more thorough examination of the patent, such that the patent would either not be granted or be severely limited, such that it no longer posed a competitive threat. The other procedure that they could do, and Professor Rai spoke a little bit about this with respect to the re-examine procedure, was seen as even more cumbersome from an inter partes perspective. And we saw that, and I think there's a lot of data out there that this procedure was rarely used because it was so cumbersome and took a long time to accomplish. And so what I think IPR has done, it's given third parties a greater ability to participate in the patenting process, specifically in industries in which they're competing or which they have specific knowledge about. And some would argue that it also gives the PTO a chance to do a more thorough review of patents, especially as we saw in Professor Wasserman's presentation, that an examiner only gets about 19 hours to review a patent application. And when you think about some of the blockbuster patent applications that are out there, and you think that they've only been reviewed for 19 hours by a patent examiner, this, an additional review would seem to be something that we would want. So I think the data is relatively conclusive that IPR has increased third-party participation in the patent system, and the appeal, and we'll talk about this a little bit in the Q&A, is somewhat undeniable from a efficiency standpoint, from a time standpoint, from a cost standpoint as well. Now we talk about and we look at who actually uses IPR in practice. The law says that any third party other than the patent owner can petition for an IPR. What we see in practice, however, is that generally speaking, the users of an IPR, the petitioners of an IPR, are accused infringers, or potentially accused infringers, or competitors of the patent owner in most cases. The data suggests also that it's very, very rare for either party in an IPR to be pro se or unrepresented. Generally, both parties are represented by experienced patent attorneys. in instances where we've seen one party not represented by counsel, there's a Stanford Technology Law Review article by Daniel Green that's found that most of those instances are patent owners that are defending their patent. And then finally, just in the pharmaceutical context, we've seen a lot of generic ANDA filers use the IPR process to challenge the validity of Orange Book patents, for example. And overall, I think that the data, if you look at the data, I think the data would suggest that patents in this area are more resilient to challenge than their counterparts in other technology areas. So I would argue that the IPR process has certainly made the patent system more accessible by increasing participation by third parties. And I think it's also had a meaningful impact on the quality of patents that are granted. And you could argue that this is a overall more efficient process than some other alternative blanket measures that we could use to increase patent quality. Because the patents that are challenged under the IPR process are selected presumably because they have some commercial value or are important in some way to a third party.
Thanks very much. So I want to jump right into discussion, and I'm going to start with you, Professor Rye, on this, but this is for the whole panel. We've had some time with IPR now for it to settle, and I want to know what you think of the program as it's currently implemented. Is it achieving the intended results, or could the IPR be made to function better?
So I think that, as I said, it wasn't really entirely clear which piece of the AIA post-grant opposition process would end up catching fire, if you will. So IPR ended up catching fire, but I can't say that there was a strong sense that that would be the piece. That said, I think there was a general sense with respect to all three procedures that one goal was to be a substitute for Article 3 litigation for all the reasons we've articulated. And that clearly has happened. So an article I wrote with Saurabh Rishabhaka back in 2016 looked at the so-called, what we call the substitution effect of IPRs. And in most cases, with Orange Book patents and biologics patents being a small exception, we have parallel litigation going on, as Professor Robinson has noted. And so there is a substitution, and ideally what happens is that the district court litigation is stayed pending what's going on at the PTAB. Now, one, I think, feature of the initial legislation which didn't contemplate IPR as being as hot as it is, was that it made the stay discretionary. And I'm not sure that that was necessarily the best thing to do, given the different predilections of district court judges. And that was more of an issue when there was more forum shopping, particularly in the Eastern District. That's become less an issue given the diminution in forum shopping after TC Heartland. So that's one piece of it that I think could be, to really enforce the substitution effect, I think we should have less discretion in the stay piece of things. I'm glad that the PTO, and this is not necessarily loved by all folks who think that there are a lot of bad patents out there, but for the substitution reasons, I'm glad that the PTO, and I supported this in comments that I and others made to the PTO, moved towards having a claim construction that's parallel to that of the district courts. I think it creates efficiencies of the sort that we want for purposes of substitution. I should note, however, that substitution is not the only goal, and it was not ever contemplated as the only goal. Again, there's this idea that the administrative agency should be able to re-examine its own work because it is the entity that has done the work and should, in the first instance, be the entity that should be able to opine upon it. And I think in that regard, there is an unfortunate tendency on the part of both the Federal Circuit and most recently the Supreme Court to create create obstacles, excuse me, to the use of access, essentially, as Professor Robinson has noted, to access to IPR by entities that aren't directly being sued. So one of the set of challenges that the Federal Circuit has created is that it's harder to appeal a negative IPR decision against you as somebody who's opposing a patent then I think would be ideal. And I think the Federal Circuit has probably taken Article 3 standing a bit too far in its jurisprudence in that regard. More recently, and this is something that I'd like to return to if we talk about drug and biologics patents, the Supreme Court has issued a decision called Return Mail that says the government can't be a person that uses the IPR process. And I think that's a very significant potential impediment to our collective goal of wanting to lower drug prices. And we can talk about that as well. And then finally, last but not least, perhaps, and this goes to the general idea that the PTAB came into being at a time when the Supreme Court's and hence Federal Circuit's jurisprudence in the administrative law area became much more hostile to administrative adjudication, to the point where some prominent commentators are even saying that administrative adjudication is under siege. The Arthrex decision has created, and oil states before that, although oil states ultimately didn't invalidate the PTAB, the Arthrex decision, I think, has created this cloud of uncertainty over the PTAB that I really think is unfortunate. So it seems to me there Congress needs to act. If and when the Supreme Court takes the case, perhaps they'll act. But even prior to that, I think Congress needs to act. So those are some of the ways. I don't know that those are ways in which all of them are not necessarily ways in which the PTO could improve IPR. Some of them are problems that have been created by Supreme Court jurisprudence and administrative law, regrettably.
Great. And Professor Wassman and Robinson, I want to give you a chance to chime in here.
Keith, did you want to add anything?
Well, so I would just say to Professor Rye's point, I think one of the most encouraging things, and she mentioned this in her opening comments, was about who are the decision makers in this process. And so when you look at the district court litigation, you have district court judges who are generalists. You have decisions on patent validity being left up to juries, and contrast that with the PTAB and the IPR process. And when the PTAB was being formed, I know anecdotally that they went out of their way to try and recruit former Federal Circuit clerks, people that had practice, to become judges for the PTAB. And I think it's, from a practitioner standpoint, it's very encouraging when you have a panel of people that have expertise in this area, not only from a technical standpoint, but also understand the case law and understand the legal tests that are involved with patent validity. I think that's one thing that before IPRs, and we often, when we talk about IPRs and criticize them, we often forget what it was like before IPRs. And before IPRs, the patent bar was, parts of the elements of the patent bar were extremely concerned about how these cases were being decided by generalists and juries. And so I do think that having this specialized adjudication procedure is working as intended and is helping.
Yeah, and I would just add one thing too. I mean, I agree with a lot of what Professor Rye said, about maybe we need to rethink the stay, right? That we might have too much simultaneous PTAB and district court litigation occurring at the same time. But I would just also bring in this idea that too, if you compare PTAB to other types of agency adjudication, right, and you look at the protections that PTAB has, it comes out really well. Right. I mean, it has many of the protections that you would want to see in sort of an agency adjudication. I think some of what we might see is just kind of growing pains with the sort of patent bar or individuals less kind of comfortable or familiar with sort of agency adjudication that we've had, I think, in many other fields for a long time.
And before we move on, I just want to pick up on a point that Professor Rai brought up, that when this system was being designed, no one knew which post-grant procedure would catch fire, and it was IPR. But IPR is also more limited in the grounds in which a patent can be challenged. Do you think that that's problematic, or is that something that is working as intended?
So yeah, I think it would be a good idea to think through carefully whether the grounds should be expanded. Now, the reason that the grounds were limited is because IPR is available throughout the life of the patent, and there's no, except for the case where there's a 1-year window to challenge if the patent is asserted against you, there's no other real time limitation, which creates, you know, on the part of some, a concern about finality. And so I understand that point, but I do think that there's a way to strike the balance so that the grounds aren't quite so limited, perhaps through some mechanism where we limit the time range in which an IPR can be brought. Because I do think one thing that has become clear is that the PGR time window, the post-grant review time window, which is where all grounds can be used, is for the US system at least too limited.
All right, and I want to move on to a really interesting policy debate that's been going on for almost 20 years. Before I do that, Professor Wasserman, can you give us just a little bit of background in explaining the different sort of pre-grant and post-grant error correction strategies there are in policies that are being contemplated?
Yeah, so, you know, we've been talking a little bit about this right now. And so you can imagine, right, you have the patent office and essentially you could put resources early on at the examination stage, right, so that the examiners just don't make any errors, right? That no one really thinks is going to be ideal, right? You would have to probably give them thousands of hours and lots of resources. So they're going to make some mistakes, right? There's just a matter of how many they should be making. And I personally feel like we could increase the resources some at the patent office to cut down a majority of those mistakes. But even if we increase the resource, some are going to happen. So then you can imagine some other ways to correct those invalid patents. So you could have something called a pre-grant system, right? Where somebody could be able, we have this on the trademark side of the Patent and Trademark Office, where someone could essentially challenge the grant of a patent before it issues. So there's some sort of period where maybe it's, you know, conditionally issued patent, right? Where somebody can come in and challenge in a pre-grant opposition system that would look kind of like an adversarial system that we have at post-grant. Right now. Then after the patent issues, what we've been talking about right now is IPR or PGR, where you have a post-grant opposition system. So now the patent's been issued and you can bring it back to the Patent and Trademark Office and have them essentially take a second look at an error. And then finally, of course, we know that we have patent litigation. And we've always had that as another way to weed out invalid patents. Now, I think when we're thinking about the patent system, we have these whole number of tools to increase patent quality. And the question is how much should we give for each one, right? We've created a system now that we've got litigation, PTAB, and we spend, I think, relatively sort of minimal resources, at least in comparison to other agencies. So for example, the European Patent Office spends about twice as much on resources reviewing an application than we do. And they've decided to spend a lot more resources up front, arguably to let fewer invalid patents up in the beginning. So a big sort of debate is sort of how do you choose among this sort of menu to optimize from us as society and limit the number of invalid patents you're issuing and perhaps valid patents you might be rejecting.
Great, and I'm just going to stick with you briefly because you were actively involved in this debate with Professor Frakes. But in 2001, Professor Mark Limley wrote an essay called Rational Ignorance at the Patent Office, which I think spawned a lot of these debates about where to put resources in correcting error rates. Can you just briefly just walk us through what that debate is? And then I'd like to turn to the other panelists to chime in.
Yeah, so Professor Limley wrote a very influential piece, right, where he essentially argued that it doesn't make sense to increase the resources early on at the Patent Office for the review of all patent applications because, according to him, so few patents end up being litigated or licensed and turn out to be economically valuable that in those rare instances, we should just rely upon litigation ex post to weed those out. So this is a classic debate we see in law all the time, ex ante regulation, or should we wait till ex post kind of enforcement? And so Mark had, Professor Limley had written this article and he followed it and did a back of the envelope sort of cost benefit analysis in order to support his proposition. And he came out suggesting the cost of doing so way outweigh the savings. So Professor Rye had actually pointed out, as well as Professor Frakes with myself, that many of the sort of calculations that Professor Limley had done, he had some hard data, but he lacked a lot of data. So he had to essentially assume or sort of guess some of the key parameters associated with this. So if you increase examiner time, how many fewer patents will they issue? He essentially had to guess that number, right? And he had to do so on a number of things because he didn't have the available data. And really, we thought those sort of guesses in part led to his conclusion to say it's not cost effective. So one of the things that Professor Frakes and I had recently done was revisited this question. We have a lot more data now, but we're also able to draw on some of our previous work to use more sophisticated empirical techniques to provide estimates of these things, right? So if you double examiner time allocations, instead of just guessing how many fewer invalid patents you'll issue and how many fewer patents would be litigated, we're able to use some sort of techniques to get estimates of these. And when we redid this, we actually came out the opposite way. And we think that there's reasons to believe that it would be beneficial to increase resources to the Patent Office in order to issue fewer invalid patents. Now, the one thing I want to say is we did this for all sort of patent applications, but I think the case is even much more stronger for certain subsets of applications. So for example, Professor Frakes and I have recently sort of looked at pharmaceutical patents, right? These are clearly pharmaceutical patents that end up getting listed in the Orange Book. These are incredibly valuable patents, right? So if you think about the Patent and Trademark Office making a mistake on these are going to be really costly to society if you make a mistake. This could block generic entry for some particular period until they get litigated and invalidated. So we think there's clearly kind of some subsets of applications where, to us at least, it seems like it's a no-brainer that we should maybe put some more resources early on to make these, arguably better decisions on these patents early on. And that could include things like pharmaceutical patents. That could also include patent applications that has some sort of related family member that's being litigated or that's in a PTAB adjudication, right? So I think even if you're not comfortable with increasing the resources to all applications, which we are, but I understand some people may not be, there's clearly some subsets of, I think, low-hanging fruit where it would make a lot of sense for us to increase resources ex ante instead of just relying on ex post litigation.
And Professor Rye, I want to bring you in here because it's a good part. IPR is obviously part of this balance of different strategies for increasing patent quality, and you've done a lot of work specifically on how IPR can be helpful for clearing biological patent thickets. Do you think that more work could be done here? Do you think IPR is a good place to put our resources? What do you think the mix should be as far as reducing these issues?
So, like Melissa, I think that there's probably a balance to be struck, and I think more resources are needed ex ante, particularly in these areas, in these subsets where we know the patents are going to matter. So, for example, a patent patent has been granted, excuse me, on a core drug patent, and then you know that, as often happens, there will be subsequent patents filed after that. The examiner should be aware that the patent that she granted is now associated with an approved drug. So that sort of thing, I think that coordination between different agencies in some cases might be very useful. I do think that in terms of in biologics in particular, there has been a fairly robust use of the post-grant system, and I think that's encouraging because these thickets are particularly problematic in the biologics arena, where we now have 40% of our biopharmaceutical spending. So I'm collecting some data right now on biologics, and it looks like a really substantial majority of the patents that are challenged at the PTAB aren't even in litigation in the biologics context. So this is clearly a way to clear patent thickets. And I think that's good because in some of these cases, there is the level of information one needs to clear the thicket in terms of priority is fairly substantial. I think a lot more could be done with IPR to clear those thickets. And I think, again, there needs to be some improvement in IPR. I think currently the PTAB, perhaps because it feels like it's under fire all the time, has a very high standard for what constitutes a printed publication. It can't use any prior art other than printed publications and patents, which can be problematic as well. So it seems to me that there could be improvements that were made in IPR also, in addition to having more resources devoted in ways that, are, I think, fairly clear with respect to the ex ante situation.
And Professor Robinson, I want to turn to you here. One problem that seems pretty common, whether you're a patent plaintiff or defendant, is just that the system is very expensive to access. And, one of the hopeful features or benefits of IPR is that it's, faster and far less expensive than litigation. So do you think that IPR is providing better access, and what kind of improvements do you think could be made?
Yeah, definitely from a time and cost standpoint, I think IPR is improving access. If you look at the time it takes to get a final decision in IPR, max is around 18 months, probably at the limit at 18 months, versus minimum of 3 years of district court litigation. I think it's pretty clear that IPR is probably the preferred choice from a time standpoint. And then if we look at the data on cost figures that are out there, the cost of IPR hovers around, the average cost, I should say, around $300,000. It could get a little bit more expensive than that. But your average cost for district court litigation is going to easily be in the millions of dollars. And that's well before any appeal to the federal circuit. So from a cost standpoint, it's certainly more strategic and less expensive to pursue the IPR route than district court litigation. Now, what I will say on the other side, to be fair, is that because, and Professor Rai spoke about this a little bit, because these IPR processes are seen as a substitute, or could play as a substitute role for litigation. You see now a lot of law firms, a lot of practitioners include sort of the possibility of an IPR challenge in their full litigation strategy. And so in addition to patent applicants, when they begin to the process of filing a patent application and prosecuting that application through the USPTO, they do so with in the back of their mind, they have the idea that, oh, hey, we may face an IPR challenge eventually. And so they prepare for that as they are filing, as they are working their patent application through the grant process. I think the good thing about that is that it provides for a better quality application. The flip side to that may be that it may be a little bit more costly to prosecute the patent. And so you have to weigh sort of the cost and benefits of that. But that is sort of one of the results. So I hope that kind of addresses your question about cost.
Great, and I just want to bring up real quick, there's been a recent Perriman Group study. They found that IPR saved about $2.64 billion in direct costs, and then they traced that to the economic impacts that they believe that had on the industry. Do you think that these savings are being spread equitably? Do you think that, are there any improvements to be made? Since your expertise is access, I just want to get your opinion on this and how these savings are helping and how it's working and to what extent it could be improved.
Well, so no, I think so. I did read the study. I think that we're seeing savings on the litigation side. It's a lot less costly to do IPRs than it is to do district court litigation. I think, again, to be fair, I think a patent owner argument might be that it's costly to them because their patent might be subject to multiple challenges throughout its lifetime with respect to IPR, and that's an argument that you see made out there. But ultimately, I think I agree with most of the conclusions made in the study about the cost savings that this process has generated.
Great. And then finally, before we get into any of the audience questions, I just want to dig into a topic we briefly touched on, which is, there's been a few federal circuit decisions recently that have impacted IPR. I was hoping, Professor Roy, that you could start us off with just explaining what these cases are, and then whether you think it's necessary that there's some sort of congressional action to fix what the case is decided.
Right, so I think that the most important case is Arthrex, and this case involved a challenge to the setup of the PTAB, in the sense that the claim was that the AAJs, administrative judges, are not appropriately appointed, given that, and here I'll get into a little bit of geeky admin law, given that according to those who challenged their appointment, they are quote unquote principal officers, unquote, which is a term of art within administrative law, which requires, and if you are a principal officer, it requires a mode of appointment different from the mode that they are currently appointed, which is as regular officers or inferior officers. So the claim that was made to the Federal Circuit was, as a consequence, the system is unconstitutional, given the fact that they're principal officers and they enjoy protection from removal, civil service protection from removal. So the way that the Federal Circuit sliced the salami, if you will, at least a majority of the Federal Circuit, said that, okay, well, if we remove their civil service protection, they will no longer be principal officers, and therefore the way they're currently appointed is okay. Now, I think that's problematic, because a removal of civil service protection really does jeopardize a core value of administrative adjudication, which is some distance from the political process and the vagaries of the political process. So I think that the Federal Circuit decision is probably incorrect. I do think that given the level of supervision that the PTO director has over the administrative judges, the administrative patent judges, they are inferior officers even with the protections from civil service removal. But right now, at least that's the law, is what the Federal Circuit said. So if the Supreme Court doesn't overturn what the Federal Circuit said, it seems to me a very relatively surgical fix, at least, would be to simply do what most other administrative agencies do, which is have a very explicit provision that the PTO director has the opportunity or the right to review any administrative patent judge final written decision. And that could be a very small surgical change to the statute. Now, again, I don't think it's necessary, but given that what this Federal Circuit has done, I think it's, and the fact that the Supreme Court may or may not overturn the Federal Circuit, I think it's important that Congress act in a surgical manner. The American Bar Association IP section has, by the way, come out, I believe, publicly in favor of this surgical fix if necessary. So that's a positive sign.
Professor Wasserman and Robinson, do you have anything to add there?
Yeah, I would just echo, I mean, I agree with Professor Rye. I think that likely the Federal Circuit opinion is incorrect. It took a very, I thought, formalistic sort of view of what was a principal officer. But given that that's what we've got, I too think, I have written a paper with Chris Walker, who I think is on this ABA IP board, right, where he previously urged that the PTO director should be given final decision-making authority over PTAB. And I agree with Professor Rye that that would be a surgical fix to the anthrax decision, but I also think it's good from a policy perspective. It's another way that the director could bring uniformity to PTAB decisions. There's been some complaints sometimes of inconsistent PTAB decisions. I think there's sort of other good policy reasons that we should kind of harmonize the PTO with what what most of other agencies have, which is often the director will have final decision-making authority over the adjudicatory board.
And just to be fair to the other ideas, does anyone want to just quickly walk us through some of the other ideas on the table that are being considered?
With respect to Arthrex?
Arthrex, yeah.
I am not actually aware of a huge number of other ideas other than the current system is, with the lack of removal protection, is just fine, or that we should in many ways scale back what the PTAB does, so that
I think that one of the other sort of leading ideas is having a panel.
Oh, that panel idea. Okay, yeah.
And I think there's a few other ideas circulating around.
Yeah, the panel idea strikes me as certainly plausible, and I think that that's an option constitutionally, certainly, that should address the constitutional problem. I don't think it's the best policy option.
Okay. And we're getting close to time, so why don't we just go to concluding remarks? We've gone through quite a bit of the inter-party review system. What's your big takeaways? Starting with Professor Rye.
So I think the big takeaway right now is that there is a mix of tools that can be used. So in agreement with what Professor Wasserman said, there's a mix of tools that can be used, and the question is how to mix and match the tools. I think IPRs are a very valuable component of the toolkit. They're not the only component, but they're a very valuable component, and we need to be preserving them. I do worry that the way that the administrative adjudication process is being scrutinized very closely in a very formalistic way, to use Professor Wasserman's term, by the Supreme Court and hence the Federal Circuit, is going to hamstring the IPR situation in a way that's makes it less than an optimal procedure. And then if that happens and we can't change what the Supreme Court thinks is constitutional, then that creates even more pressure on the ex ante process and setting up a good ex ante process, because the constitutional limitations, even for the current Supreme Court, should be less salient there.
Professor Robinson?
Yeah, so I would say, for me, the biggest takeaway is with regard to patent quality. I think both of us can agree that we want, in the system, we want quality patents in the system. And we want the examination process to be as high quality and as robust as possible. I think also that, this process is about a decade old, less than a decade old, the IPR process. And the USPTO has already shown a great deal of flexibility, a great deal of wanting to get stakeholder input about how the process is going for them. Professor Rai mentioned early on in her comments about the PTO changing the claim interpretation rule, adjusting that based on stakeholder input. And so I think that what gives me great hope about the process is that the USPTO is willing to listen and willing to be flexible in its adaptation of the process to generate the best outcome possible.
Professor Wasserman?
Yeah, I would say my big takeaway is I think the patent system and at least with the adoption of IPR and some other changes has been moving in a positive direction to help increase patent quality. And I would echo some of the things that Professor Rice said. I think there is some questions about what the Supreme Court and Federal Circuit will do with respect to these post-grant opposition proceedings, which could limit their full ability to help on this error correction function. And what I would want to add in is I think that in particular in this sort of patent field, we need sort of more evidence-based sort of research, I think, and we're going to need that coming forward to help us sort of understand how we're going to hit this optimal mix to increase sort of patent quality, right? How much do we know we should be spending ex ante versus maybe in a pre-grant system or post-grant system versus just continuing to rely on litigation.
All right, thanks everyone for attending. We're at time. Thank you very much, panelists, for coming. It was a great conversation.